Mr. Tucker, first of all, just what is no fault?
Well, Lee, I think it's the public certainly is confused on this particular issue. No fault basically is a law that is passed to provide for auto insurance to an individual, which would permit an individual to collect from his own insurance company for the damages which he has suffered, instead of the present system we have, which requires you to sue a third party in the accident.
Well, the name first is a Madison Avenue gimmick to attract the unwary, apparently, because in truth it could more appropriately be called a subsidy for the reckless. No fault simply says that everybody injured in an automobile accident, without regard to fault, will be compensated just as fully and to the same extent as is an innocent accident victim under today's fault system. So the people that would be benefited by the broadened coverage would be the person who self-injured himself in a single car wreck, upsetting it on a road or hitting a fixed object. That's roughly 1/3 of the automobile accidents that result in injury or loss of life. Incidentally, 40% of your fatalities in single car accidents. A rather astonishing figure.
What happens to those people, Mr. McLean, if they're uncovered by the system?
Well, they're covered by their own private insurance. Your medical payments insurance on automobile insurance covers their medical bills, and any private insurance they have, such as hospital insurance or disability insurance policies or life insurance or accidental death policies would cover them. But since they injured themselves, nobody else was at fault for it. So there's nobody else to pay them.
And you're saying then that those other forms of insurance were not mandatory.
That's right.
And they would be mandatory under no fault.
That's right. So 1/3 of your accidents fall in that category. That leaves 2/3 that involve 2 or more cars, and in those, the court's decisions run about 50%, with the plaintiff winning and 50% the defendant winning. So if we divide the remaining 67 auto accidents out of 100, 50-50, we find that 33 of them, again, are wrongdoers, at fault, negligent in the accident. Those people would collect under the new no-fault concepts. So you'll have 3 times as many people collecting, and this means 3 times as much insured loss cost, and it means ultimately up to 3 times as much premium.
Of course, this has been one of the arguments of advocates of no fault, that rates would fall. You're saying then that this would actually drive rates up?
There's no way to pay the same benefits to 3 times as many people and have rates go down. The only way would be to cut benefits, and this has been done under nearly all the no-fault plans in other states.
But let me tell you where the argument breaks down. You're right. There are about 2/3 of the people that do not collect on the present system, and this is where the fault in the system lies. That's what the Department of Transportation showed in their report, which was issued last March. But where we have a savings, Lee, we rebalance our benefits. The Department of Transportation study showed that persons with injuries under $500, or economic losses, I should say, under $500, actually collect 4 or 5 times their actual economic losses. And the reason for that is it's easier for an insurance company to settle for maybe $1,500 or $2,000 than it is to go to court over it. So you have settlements that are much more than the actual economic loss. So under a no-fault system, we would cut that out and cut the fat out of the system, so to speak, and provide for actual economic payments. So if a person had $500 worth of economic loss, then you'd be paid $500. So the savings would counterbalance. Then the savings would be applied to those other 2/3, and it would balance off.
You're saying then that no-fault insurance will lower the rates?
Well, it all depends on what type you're talking about, Lee. If you're talking about a total no-fault, which is the plan that's advocated by the American Insurance Association, which I represent.
And that means you just don't go to court?
Well, you don't have to. You have a contract between the driver or the operator of the automobile, and any passengers in his car, or if he strikes a pedestrian, or if he himself is injured in any kind of accident, irrespective of fault, running into a telephone post, collision with another car, any type of accident, then his own insurance company pays him. You're not required to go to court. Now, the lawyers raise the objection, well, you're doing away with the right of the individual for a cause of action or a court action. We don't say that we deny the individual the right of jury trial. If he has a dispute with his own insurance company, then he has a right of jury trial and can sue his own insurance company. But the question, of course, or the fact is that if you settle with your own insurance company, you have much more chance of settling and get a more realistic settlement than you would with someone else's insurance company, which you have under the present system.
So this first form of no fault, the pure no fault, you say will lower the rates? I
think it probably would here in Texas. There should be some savings. I think the chances of a total no fault in Texas is very minimal at this particular time.
What are the other forms of no fault, and what will they do to rates?
Well, you have basically three forms, Lee. You have the total no fault, which we've just discussed. You have the modified no fault, which provides for a limitation on pain and suffering suits, so to speak, up to a certain amount. Like in Massachusetts, you have to have medical expenses exceeding $500 before you can bring a lawsuit against the other party. And in Florida, of course, you're required to have medical expenses up to $1,000. Then you bring suit against the other party.
Under no-fault plans, pain and suffering has a limitation on collections, and in some of the plans, it's 50% of your medical and hospital expense. That's the ceiling. The idea here was that pain and suffering was an illusory, imaginary type of a complaint. This is not so. Pain and suffering includes the loss of use of your reproductive organs, male or female. You could go through life, a man impotent, a woman barren, and collect half of the cost of the medical bill at the time your injury occurred, perhaps $50 or $150. That's pain and suffering. Pain and suffering, to use another illustration, is the loss of an eye. You've lost an eye, you collect for that, but what has it done to you in limitations of the rest of your life? In the precautions you take to protect your one remaining eye? What's it done to your depth perception? These are pain and suffering benefits. Scarred face, a child that'll go through life with a scarred face. Under no-fault plans that have these artificial limitations, there would be a collection of only 50% of the medical expense. So there are real valid pain and suffering damages.
One last question, Mr. Tucker. Of course, your insurance association is composed of companies like Travelers and Fireman's Fund and the Hartford Group, and they favor no fault. And there seem to be other insurance companies that don't favor it. Why is this?
Well, I guess it's just like politics, Lee. You have philosophical aspects. Some people are conservative and some are liberal. I think it's mainly because of the philosophy of certain number of companies. The smaller, independent type companies are opposed to it, but it's amazing how they're coming around. In the various states now, the so-called regional companies or smaller companies are jumping in behind legislation that provide for no fault. So it's a quick change that's been brought about in the last year, I would say.
What are the chances for no fault in Texas?
Oh, you mean this year?
This year,
I
yes.
would say the chances are very slim right now unless the governor puts it on special call, and I think next year we'll have an excellent chance.